Welcome back to For the Record here on the Law and Crime Trial Network. I'm your host, Anjanette Levy. Thanks for being with us. And we are talking Johnny Depp versus Amber Heard. The case may be in recess. The trial may be in recess this week, but there's still a lot to talk about. And when we went to the last break, we were talking about that cosmetic palette that Amber Heard's lawyer, Elaine Bredehoft, held up in her opening statement, saying that, you know, Amber Heard, she carried this palette, this color-correcting palette with her the entire time she dated Johnny Depp in order to cover bruises and cuts and things like that. It's made by a company called Milani. This company, Milani, then released a video on TikTok saying, guess what? You know, we didn't make this palette. This didn't come out until 2017. And she was with Johnny Depp like 2011 through 2016. So the product they held up in opening statements wasn't even available yet. I contacted Amber Heard's team about this when this first came up and the TikTok video came out, and they said, you know, well, she didn't mean that specific palette. She meant something like that, and that they felt that the company was trying to capitalize on, you know, get some free publicity or some free PR out of a domestic violence case. So Neil Rockind, you're a defense attorney. You would possibly be up there representing Amber Heard. What is your feeling about this? Because I tend to feel like you held up this thing and said this is what she carried, right? And so you're representing that to the jury, and now you're kind of backpedaling, at least through your spokesperson.
So this is a huge point. It is an unforced error. Anytime you've ever seen, let me give you something comparable in the sports arena. Guy goes in and he can make a layup and it's 2 points, right? But instead of that, he wants to do some kind of triple reverse jam, tomahawk jam, where he does a somersault. He clangs it off the front of the rim. Nobody ever forgets that. You can try to explain away all the reasons why you did that, but that's an unforced, embarrassing error. And the reason why it's so important is that her lawyer brought that up. She sponsored that evidence. She sponsored that argument. And to now come back and say, oh, well, we were wrong. We were just using that to demonstrate something. I mean, you're the one who's supposed to know the case. And that is a huge unforced error. It makes the defense look like everything they're saying, or at least on that point, is just like, you know, I mean, they're just trying to patch up or come up with some kind of patchwork defense to these allegations. You could have just said, well, she has a cover-up. She has cover-up that she used. Why identify the brand? Why hold it up? Why hold it up in front of the jury in opening statements so that later the company says, we didn't make that at that time. Oh, we didn't mean this one. If the lawyer knew that they didn't make it, she should have just said, look, we didn't make this one at that time. We don't have the exact one she was using, but this is just for demonstrative purposes. But she said this one right here. And they're going to be able to show that that one wasn't in production. I mean, it's terrible. It's an unforced error. It's a missed done.
I'm wondering, Neil, you know, we haven't even gotten to we haven't made it to the beauty regimen point of the testimony yet. So as we know, opening statements are not evidence, neither are closing arguments. So do you hammer on that as Johnny Depp's attorney during cross-examination? Obviously, Amber Heard now knows that that product wasn't made until 2017. So she's going to tell us the products she uses, right? Aren't we going to get schooled in a lesson in what products Amber Heard uses to cover bruises, cuts, etc.?
Yes. Questions are all yes. Any lawyer would get up there and say, you sat there during your lawyer's opening statement. She's your representative, right? She's your chosen lawyer. She got up there. And to this jury, these folks, this is how I would conduct the cross. You sat there and you knew at that time that your lawyer was she was talking about this cover-up. She was alleging this was the makeup that you used. And you knew that entire time that she was misrepresenting something to the jury. And you never corrected it. You never said, you know what, she's wrong, or you're wrong, or encouraged her to get up there at some point during the trial, at any point, and say, you know what, it was a mistake. You allowed her to actually say that to mislead this jury, or to potentially mislead this jury. She can say whatever she wants. The jurors are going to remember that. She can say whatever she wants, but she sat there as her lawyer made that opening statement on her behalf. and she didn't correct it. Sure, she can try to correct it on the witness stand, but a good cross-examination that just focuses on those points, that's your rep got up there, your rep said that, you were sitting there, you never called her over, you've had this trial's been going on for several days, several weeks, you never once attempted to correct that. You would hope that we would never figure it out, that we would never catch on. The answers don't matter at that point. The jurors have already seen the fact that her lawyer, she was willing to let her lawyer go out on that limb. I hate to use a Pirates of the Caribbean phrase, but she let her lawyer go out there in that plank.
Neil, I hate to cut you off, but we have to take this break. And Elaine Bredehoff got that palette from somewhere, right? Somebody told her about it. Neil, thanks for being with us this hour. Joseph Scott Morgan is going to stay with us. We hope you do too. While we take this quick break, you are watching Law and Crime.